helps children in foster care significantly. Children in care are among the most at risk educationally in our nation. They frequently experience school enrollment delays, difficulty transferring school records, and challenge in having complete and up-to-date academic records. Prior to changes to FERPA, the Family Educational Rights and Privacy Act, child welfare agencies frequently experience delays and sometimes an inability to access a child's educational records. This was particularly challenging because as child welfare professionals, they had a heightened responsibility to make decisions that were in the best interest of the children in their care. The USA Act has eliminated some of the leading barriers to child welfare professionals being able to make good educational decisions and access educational records in a timely way. The USA Act is significant for lawyers and judges and important for them to know about. First, courts and legal advocates play an important role in monitoring the implementation of the USA Act. The Act has created a new exception to allowing child welfare agency representatives to have immediate access to the educational records for children when they are in their custody. Courts and legal advocates need to know this from early hearings on throughout the life of a child welfare case, so that whenever there is a school change or a need for timely access or transfer of records, that courts can monitor and ensure that child welfare agencies are getting those records in a timely way. Additionally, the USA Act adds an additional tweak to the existing court order exception. And so now, when there is a court order allowing access to educational records for anyone involved in the child welfare case, or anyone who needs access to those records, there is no longer any need for an additional notice to be provided to parents by the educational agency, as long as those parents have been parties to the case in which that court order has been issued. What that means is there would not be an additional delay in order for those records to be released by the educational agency to whoever is listed in the court order. It also makes clear that parents do have notice of that release through the original court order itself. So let's think about how this would play out for a child in care. Let's assume that we are at an initial removal of a child who's been removed on an emergency basis. Parents' whereabouts are unknown. So a child welfare worker is in the situation of trying to make some very quick decisions about whether or not the child should remain in their current school or be re-enrolled in a new school, albeit doing that without any access to the parents or information related to the child's educational experience. Prior to the changes, there were times when workers would reach out to schools, and schools, because there wasn't a parental consent or a timely court order, would not be able to release those records in a quick way. Even with a court order, because of the prior additional duplicative notice requirement, the delays would sometimes cause quick decisions to be made without all the pertinent and important information. Lawyers and judges really can play an important role in these decisions when there are changes in school placement, and in particular at initial stages of the case, to be completely sure that those upfront decisions about school stability and appropriate school placement are being made with all of the educational information necessary to ensure that those decisions truly are best for kids.